Welcome to SNS Academy. I am Satyanar Saha. Good evening, students. We are discussing about Indian Polity by M. Laxmikanth, 7th edition. Today, chapter 8. Already 7th chapter we covered. So today we discuss about fundamental rights, chapter 8. मौलिक अधिकार जिसको बोलते हैं, जो कि थर्ड पार्ट ऑफ द कॉन्स्टिट्यूशन में है, फंडामेंटल राइट्स, और इसमें आर्टिकल्स 12 से 35 तक दिया गया है और ये यूएसए कॉन्स्टिट्यूशन से डिराइव किया गया है. द फंडामेंटल राइट्स एनश्राइन्ड इन पार्ट थर्ड ऑफ द कॉन्स्टिट्यूशन फ्रॉम आर्टिकल्स 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA, Bill of Rights. Part 3rd of the Constitution is rightly described as the Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. फंडामेंटल राइट्स को मैग्ना कार्टा भी बोला जाता है इंडिया में, और ये डिटेल्स में डिस्क्राइब किया गया है. और फंडामेंटल राइट्स जस्टिसेबल, मतलब फंडामेंटल राइट्स को अगर कोई वायलेट करता है तो वो आदमी सुप्रीम कोर्ट को जा सकता है और कोर्ट को जा सकता है जस्टिस पाने के लिए. द फंडामेंटल राइट्स आर गारंटेड बाय द कॉन्स्टिट्यूशन टू ऑल पर्सन्स विदाउट एनी डिस्क्रिमिनेशन. दे अपहोल्ड द इक्वालिटी ऑफ ऑल इंडिविजुअल्स, द डिग्निटी ऑफ द इंडिविजुअल, द लार्जर पब्लिक इंटरेस्ट एंड यूनिटी ऑफ द नेशन. तो फंडामेंटल राइट्स कॉन्स्टिट्यूशन के थ्रू से गारंटेड है सभी के लिए, जो कि सभी वर्ग का आदमी के लिए विदाउट डिस्क्रिमिनेशन ये एप्लीकेबल है. दे अपहोल्ड द इक्वालिटी ऑफ ऑल इंडिविजुअल्स. ये सभी आदमी को एक जैसा देखता है. और द डिग्निटी ऑफ द इंडिविजुअल, द डिग्निटी ऑफ द इंडिविजुअल कैसा सेफ्टी रहेगा और यूनिटी रहेगा, ये इसका आधार रहता है. द फंडामेंटल राइट्स आर मींट फॉर प्रोमोटिंग द आइडियल ऑफ पॉलिटिकल डेमोक्रेसी. दे प्रिवेंट द एस्टेब्लिशमेंट ऑफ एन authoritarian and despotic rule in the country and protect the liberties and freedom of the people against the invasion of the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not men. फंडामेंटल राइट्स जो कि डेमोक्रेसी को प्रमोट करता है. फंडामेंटल राइट्स इसीलिए है जो कि पर्सनल ग्रोथ और डेवलपमेंट बढ़ाता है. दे प्रिवेंट द एस्टेब्लिशमेंट ऑफ एन अथॉरिटियन एंड डेस्पोटिक रूल इन द कंट्री, और प्रोटेक्ट करता है लिबर्टीज और फ्रीडम को ऑफ द पीपल अगेंस्ट द इन्वेशन ऑफ द स्टेट, जो कि स्टेट का पावर को लिमिटेशन रखने के लिए फंडामेंटल राइट्स मदद करता है. लिमिटेशन ऑन द टायरनी, जैसे डिक्टेटरशिप नहीं आ सके. इन शॉर्ट, दे एम एस्टैब्लिशिंग ए गवर्नमेंट ऑफ लॉज एंड नॉट फॉर मैन. जो गवर्नमेंट लॉ बनाने के लिए वो मदद करता है. The fundamental rights are named so because they are guaranteed and protected बाय द कॉन्स्टिट्यूशन, फंडामेंटल राइट्स गारंटेड और प्रोटेक्टेड बाय द कॉन्स्टिट्यूशन है, which is the fundamental law of the land. They are fundamental also in the sense that they are most essential for the all round development, material, intellectual, moral and spiritual of the individuals. तो फंडामेंटल राइट्स इसीलिए इसको बोला जाता है जो कि एसेंशियल है सभी का ऑलराउंड डेवलपमेंट के लिए, जैसे मटेरियल हो, इंटेलेक्चुअल हो, मोरल हो और स्पिरिचुअल हो, यही एंगल में ऑफ द इंडिविजुअल्स. ओरिजिनली द कॉन्स्टिट्यूशन प्रोवाइडेड फॉर 7 फंडामेंटल राइट्स. कॉन्स्टिट्यूशन 7 फंडामेंटल राइट्स प्रोवाइड किया था, लेकिन एक कैंसिल हो गया. राइट टू इक्वालिटी जो कि आर्टिकल 14 से 18, राइट टू फ्रीडम आर्टिकल 19 से 22, राइट अगेंस्ट एक्सप्लॉइटेशन आर्टिकल 23 से 24, राइट टू फ्रीडम ऑफ रिलीजन आर्टिकल्स 25 to 28, कल्चरल एंड एजुकेशनल राइट्स आर्टिकल 29 to 30, राइट टू प्रॉपर्टी आर्टिकल 31, राइट टू कॉन्स्टिट्यूशनल रेमेडीज आर्टिकल 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present there are only 6 fundamental rights. These are mentioned in Table 8.1. तो 6 फंडामेंटल राइट है. फीचर्स ऑफ फंडामेंटल राइट्स. द फंडामेंटल राइट्स गारंटेड बाय द कॉन्स्टिट्यूशन आर कैरेक्टराइज्ड बाय द फॉलोइंग. सम ऑफ देम आर अवेलेबल ओनली टू द सिटीजन्स while others are available to all persons, whether citizens, foreigners or legal persons like corporations or companies. तो फंडामेंटल राइट्स 2 टाइप का है. एक तो इंडिविजुअल के लिए लागू होता है और ग्रुप सभी वर्गों का आदमी के लिए लागू होता है. द फंडामेंटल राइट्स दैट आर अवेलेबल टू फॉरेनर्स आर मेंशन्ड इन टेबल 8.2. तो यहाँ पर 8.1 जहाँ की फंडामेंटल राइट्स का लिस्ट आउट किया गया है, जैसे राइट टू इक्वलिटी आर्टिकल 14 to 18. आर्टिकल 14 क्या करता है ना, इक्वालिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉज. इक्वालिटी बिफोर लॉ, लॉ सभी के लिए इक्वल है एंड इक्वल प्रोटेक्शन ऑफ लॉ, ये 14 है. 15 प्रोहिबिशन या डिस्क्रिमिनेशन का बारे में बोला गया है. डिस्क्रिमिनेशन ऑन ग्राउंड ऑफ रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ. इक्वालिटी ऑफ अपॉर्चुनिटी इन मैटर्स ऑफ पब्लिक एम्प्लॉयमेंट, ये आर्टिकल 16. आर्टिकल 17 जो कि अनटचेबिलिटी का abolition of untouchability and prohibition of its practice, ये आर्टिकल 17 है. abolition of titles except military and academic, जैसे राय बहादुर पहले दिया जाता था, वो सब एबोलिश कर दिया गया है, वो सब नहीं दिया जा सकता. दीज आर द राइट टू इक्वालिटी 14 to 18 से. और राइट टू फ्रीडम, जैसे प्रोटेक्शन ऑफ 6 राइट्स रिगार्डिंग फ्रीडम है, फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, फ्रीडम ऑफ असेंबली, एसोसिएशन, मूवमेंट, रेसिडेंस, प्रोफेशन, ये आर्टिकल 19 है. प्रोटेक्शन इन रेस्पेक्ट ऑफ कन्विक्शन फॉर ऑफेंसेस आर्टिकल 20. प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी, ये है आर्टिकल 21. राइट टू एलिमेंट्री एजुकेशन आर्टिकल 21A. प्रोटेक्शन अगेंस्ट अरेस्ट एंड डिटेंशन इन सर्टेन केसेस, ये है आर्टिकल 22. राइट अगेंस्ट एक्सप्लॉइटेशन आर्टिकल्स 23 एंड 24 है। प्रोहिबिशन और ऑफ ट्रैफिक इन ह्यूमन बींग्स एंड फोर्स्ड लेबर, प्रोहिबिशन ऑफ एम्प्लॉयमेंट ऑफ चिल्ड्रेन इन फैक्ट्रीज, ये आर्टिकल 24 है। राइट टू फ्रीडम ऑफ रिलीजन, आर्टिकल 25 से 28। फ्रीडम ऑफ कॉन्साइंस एंड फ्री प्रोफेशन, प्रैक्टिस एंड प्रोपोगेशन ऑफ रिलीजन, ये है आर्टिकल 25। फ्रीडम ऑफ मैनेज रिलीजियस अफेयर्स, आर्टिकल 26। फ्रीडम फ्रॉम पेमेंट of taxes for promotion any religion, article 27. Freedom from attending religious instruction or worship in certain educational institutions, article 28. Cultural and educational rights, article 29-30. Protection of language, script and culture of minorities, article 29. Right of minorities to establish and administer educational institutions, article 30. Right to constitutional remedies, right to move the Supreme Court of the enforcement of fundamental rights including the writs जो कि habeas corpus, mandamus, prohibition, certiorari, quo warranto, ये है आर्टिकल 32. These are the fundamental rights. Then they are not absolute but qualified, जो कि फंडामेंटल राइट्स का लिमिटेशन है। फंडामेंटल राइट्स स्पीच के बारे में दिया गया है, मतलब एक गाली गुलौज ये नहीं दे सकते हैं। वर्ड का लिमिटेशन इस्तेमाल करना पड़ेगा। The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable देखा जाएगा। जो बोला जा रहा है वो reasonable है या नहीं, restrictions are reasonable or not, is to be decided by the courts. Thus, जब कोई फंडामेंटल राइट्स का वायलेशन के लिए कोर्ट जाता है, वहीं पर देखा जाता है जो ये रीजनेबल है या नहीं है। After that, it will be taken. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. All of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. They are justiciable, means fundamental rights अगर वायलेट होता है तो उसका जस्टिस लिया जा सकता है, इसीलिए बोला जाता है जस्टिसेबल, अलाउइंग पर्सन टू मूव द कोर्ट्स फॉर देयर एनफोर्समेंट if and when they are violated. They are defended and guaranteed by the Supreme Court, hence the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the High Courts. They are sacrosanct or permanent. The Parliament can curtail or repeal them, but only by a constitutional amendment act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the constitution. Fundamental rights, FR for foreigners, यहाँ पर फंडामेंटल राइट्स दो टाइप का है, जो कि इंडिविजुअल के लिए और एप्लीकेबल टू ऑल। इंडिविजुअल के लिए कौन कौन सा एप्लीकेबल होता है? 15, 16, 19, 29, 30, और सभी के लिए अप्लाई होता है 14, 20, 21, 21A, 22, 23, 24, 25, 26, 27, 28। जो कि आर्टिकल 15 प्रोहिबिशन ऑफ डिस्क्रिमिनेशन ऑन ग्राउंड्स ऑफ रिलीजन, रेस, कास्ट, सेक्स और रिलीजन ऑफ बर्थ, इक्वालिटी अपॉर्चुनिटी इन मैटर्स ऑफ पब्लिक एम्प्लॉयमेंट आर्टिकल 16 है, 19 प्रोटेक्शन ऑफ राइट 6 राइट्स regarding freedom, speech and expression, assembly, association, movement, residence, profession, protection of language, script and culture of minorities, right of minorities to establish and administer educational institutions, equality before law and equal protection of laws article 14, ये है सभी के लिए. Protection in respect of conviction for offences article 20, protection of life and personal liberty, it is article 21, right to elementary education article 21a, protection against arrest and detention in certain cases article 22, prohibition of traffic in human beings and forced labor, prohibition of employment of children in factories article 24, freedom of conscience and free profession, practice and propagation of religion, freedom to manage religious affairs article 26, freedom from payment of taxes for promotion of any religion article 27, freedom from attending religious instruction or worship in certain educational institutions article 28. They can be suspended during the operation of a national emergency except the rights guaranteed by article 20 and 21. Further, the 6 rights guaranteed by article 19 are automatically suspended only when emergency is declared on grounds of war or external aggression, external emergency, and not on the ground of armed rebellion, internal emergency, जो कि सस्पेंडेड किया जाता है नेशनल इमरजेंसी. नेशनल इमरजेंसी मीन्स जब वार होता है, दूसरा कंट्री हम लोग का कंट्री को अटैक करता है, या इंटरनल कुछ रिबेलियन, मिलिटेंट रिबेलियन, ये सब होने से फंडामेंटल राइट सस्पेंडेड होता है. Their scope of operation is limited by Article 31A, saving of laws providing for acquisition of assets, Article 31B, validation of certain acts and regulation included in the 9th schedule, and Article 31C, saving of laws giving effect to certain directive principles. Their application to member are armed forces, paramilitary force, police forces, intelligence agencies and analogous services can be restricted or abrogated by the parliament. ये सब का ऊपर रेस्ट्रिक्शन है. कौन कौन सा ऊपर? आर्म्ड फोर्सेस, paramilitary forces, police forces, intelligence agencies and analogous services. Their application can be restricted while martial law is in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order. It is different from the imposition of national emergency. Most of them are directly enforceable. कुछ directly enforceable किया जाता है, while a few of them can be enforced on the basis of law made for giving effect to them. Such a law can be made only by the parliament and not by state legislature, so that uniformity throughout the country is maintained. The term state, उसका बाद किसको state बोला जाता है? The term state has been used in different provisions concerning the fundamental rights, and Article 12 has defined the term for the purpose of Part 3rd. According to it, the state includes the following. State किसको बोला जाता है ना? जिसका गवर्नमेंट एंड पार्लियामेंट ऑफ इंडिया that is executive and legislative organs of the union government. Government and legislature of states, that is executive and legislative organ of state government. All local authorities, that is municipalities, panchayat, district board, improvement, trust, etc. All other authorities, that is स्टैट्यूटरी और नॉन स्टैट्यूटरी अथॉरिटीज जो कि LIC हुआ, ONGC हुआ, सेल हुआ, ये सब. Thus, state has been defined in a wider sense so as to include all its agencies. It is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to the Supreme Court का अनुसार, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. जो कि देश के लिए काम कर रहा है उसको भी हम स्टेट बोलेंगे. Laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or derogation of any of the fundamental rights shall be void. In other words, it expressively provides for the doctrines of judicial review. This power has been conferred on the Supreme Court, Article 32, and the High Courts, Article 226, that can declare a law unconstitutional and invalid हो जाता है on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following: permanent laws enacted by the parliament or the state legislature, temporary laws जो कि ordinance issued by the president or the state governors. Statutory instruments in the nature of delegated legislation जो कि executive legislation like order, bylaw, rule, regulation or notification. Non-legislative source of law, that is custom or assets having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental rights and hence can be declared as void. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. Article 13 यही डिक्लेयर करता है जो कॉन्स्टिट्यूशनल अमेंडमेंट लॉ नहीं है, इसीलिए उसको कोर्ट में चैलेंज नहीं किया जा सकता है. However, the Supreme Court held in the केशव नंदा भारती केस जो कि 1973 में that a constitutional amendment can be challenged on the ground that it violates a fundamental rights that forms a part of the basic structure of the constitution and hence can be declared as void. Right to equality. Equality before law and equal protection of law. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the law within the territory of India. This provision confers rights on all persons, whether citizens or foreigners. Moreover, the word person includes legal persons, statutory corporations, companies, registered societies or any other type of legal person. तो आर्टिकल 14 का अनुसार द स्टेट शेल नॉट डिनाई, स्टेट किसी को भी मना नहीं करता है, सभी का ऊपर इक्वल लॉ लागू होता है, इक्वालिटी बिफोर द लॉ, और सभी आइन से सब कोई समान है. दिस प्रोविजन कॉन्फेयर्स राइट ऑन ऑल पर्सन्स वेदर सिटीजन्स और फॉरेनर्स. वो सिटीजन हो सकते हैं, एलियन हो सकते हैं, जो कि फॉरेनर सभी के लिए लागू होगा। द कॉन्सेप्ट ऑफ इक्वालिटी बिफोर लॉ इज ऑफ ब्रिटिश ओरिजिन, यह ब्रिटिश ओरिजिन से आया है। while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes the absence of any special privilege in favor of any persons. किसी को स्पेशल प्रिविलेज ज़्यादा नहीं मिलना चाहिए। The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and see no person, whether rich or poor, high or low, official or non-official, is above law. The second concept, on the other hand, connotes the equality of treatment under equal circumstances. सभी का साथ इक्वल ट्रीटमेंट होना चाहिए, both in the privilege conferred and the liabilities imposed by the laws. The similar application of the same laws to all persons who are similarly situated, and the like should be treated alike without any discrimination. Thus, the former is a negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity and justice. उसका बाद the Supreme Court held that where equals and unequals are treated differently, जहीं पर equals and unequals ये treat होता है differently, Article 14 does not apply. While Article 14 forbids class legislation, it permits reasonable classification of persons, objects and transactions by the law, but the classification should not be arbitrary, artificial or aversive. Rather, it should be based on an intelligible, differential and substantial distinctions. Rule of law. The concept of equality before law is an element of the concept of rule of law propounded by A.V. Dickey, the British jurist. His concept has the following three elements or aspects: absence of arbitrary power, that is, no man can be punished except for a breach of law. कुछ कारण नहीं होते हुए किसी को भी पनिशमेंट नहीं दिया जा सकता और पनिशमेंट को बार बार नहीं दिया जा सकता। इक्वालिटी बिफोर द लॉ, दैट इज इक्वल subjection of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. The primary of the rights of the individual, that is, the Constitution, is the result of the rights of the individual as defined and enforced by the courts of law, rather than the Constitution being the source of individual rights. जो कि कॉन्स्टिट्यूशन में इंडिविजुअल राइट्स के बारे में दिया गया है। इंडिविजुअल राइट्स का वायलेट नहीं होना चाहिए। द फर्स्ट एंड सेकेंड एलिमेंट्स आर एप्लीकेबल टू द इंडियन सिस्टम एंड नॉट द थर्ड वन। इन द इंडियन सिस्टम द कॉन्स्टिट्यूशन इज द सोर्स ऑफ इंडिविजुअल राइट्स. द सुप्रीम कोर्ट हेल्ड द रूल ऑफ लॉ is embodied in Article 14, is a basis feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Article 14 ये यहाँ का सिटीजन और फॉरेनर सभी के लिए अप्लाई होता है. एक्सेप्शन टू इक्वालिटी, इसका लिमिटेशन क्या है? द रूल ऑफ इक्वालिटी बिफोर लॉ इज नॉट एब्सोल्यूट एंड देयर आर constitutional and other exceptions to it. These are mentioned below. The President of India and the Governor of States enjoy the following immunities. जो कि प्रेसिडेंट और गवर्नर का कुछ स्पेशल प्रिविलेज रहता है. The president or the governor is not answerable to any court for the exercise and performance of power and duties of his or her office. प्रेसिडेंट और गवर्नर जब तक वो लोग ऑफिस में रहेंगे वो लोग कोर्ट में कुछ आंसरेबल नहीं है। कोर्ट उसको उन लोगों को कुछ पूछ नहीं सकता है। नो क्रिमिनल प्रोसीडिंग्स शैल बी इंस्टीट्यूट और कंटिन्यूड अगेंस्ट द प्रेसिडेंट और द गवर्नर इन एनी कोर्ट ड्यूरिंग हिज और हर टर्म ऑफ ऑफिस। उन लोगों को अरेस्ट नहीं किया जा सकता है। नो प्रोसेस फॉर द अरेस्ट और imprisonment of the president or the governor shall be issued from any court during his or her term of office. No civil proceedings against the president or the governor shall be instituted during his or her term of office in any court in respect of any act done by him, her in his, her personal capacity, whether before or after she entered upon his or her office until the expiration of 2 months next after notice has been delivered him her. No person shall be liable to any civil or criminal proceedings in any court in respect of the publication in a newspaper or by radio or television of a substantially true report of any proceedings of either house of parliament or either house of the legislature of state. No member of parliament के लिए भी स्पेशल प्रिविलेज है। No member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him, her in parliament or any committee thereof. ये आर्टिकल 105 है। No matter of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him, her in the legislature or any committee thereof. Article 31C is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained the clause B or clause of Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. The foreign sovereigns, ambassadors and diplomats enjoy immunity. The UNO and its agencies ये सब enjoy the diplomatic immunity. Prohibition and discrimination on certain grounds. ये है आर्टिकल 14, आर्टिकल 15, ये है आर्टिकल 15. आर्टिकल 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex or place of birth. इसमें डिस्क्रिमिनेशन नहीं होना चाहिए. द टू क्रूशियल वर्ड्स इन दिस प्रोविजन आर डिस्क्रिमिनेशन एंड ओनली. द वर्ड डिस्क्रिमिनेशन मीन्स टू मेक एन एडवर्स distinction with regard to or to distinguish unfavorably from others. The use of the word only connotes the discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex or place of birth. Access to shops, public restaurants, hotels and places of public entertainment. Access to shops, कोई सा दुकान में रेस्ट्रिक्शन नहीं होना चाहिए. पब्लिक रेस्टोरेंट्स, होटल्स, प्लेसेस, पब्लिक एंटरटेनमेंट. or the use of wells, tanks, bathing, ghats, road and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. वेल हुआ, पार्क हुआ, ये सब में रेस्ट्रिक्शन नहीं है, ये आदमी अलाउ है, ये आदमी अलाउ नहीं है, वहाँ पर सभी का अलाउ होना चाहिए. This provision prohibits discrimination both by the state and private individuals, while the former provision prohibits discrimination only by the state. There are 4 exceptions to this general rule for non-discrimination. The state is permitted to make any special provision for women and children. स्टेट कुछ प्रोविजन रखा है जो कि वुमेन और चिल्ड्रन के लिए. फॉर एग्जाम्पल, रिजर्वेशन ऑफ सीट्स फॉर वुमेन इन लोकल बॉडीज और प्रोविजन ऑफ फ्री एजुकेशन फॉर चिल्ड्रन. The state is permitted to make any special provision for the advancement of any socially and educationally backward classes or for the scheduled caste and scheduled tribes, for example, reservation of seats of free concession in public educational institutions. The state is empowered to make any special provision for the advancement of any socially and educationally backward classes, for scheduled caste and scheduled tribes regarding their admission to educational institutions. This also includes the private educational institutions, whether aided or unaided by the state, except the minority educational institutions. The state is empowered to make any special provisions for the advancement of any economically weaker section. इकोनॉमिकली वीकर सेक्शन को अपलिफ्टमेंट के लिए प्रिफरेंस दिया जाता है. फर्दर, द स्टेट इज अलाउड टू मेक प्रोविजन फॉर द रिजर्वेशन ऑफ अप टू 10%. अगर रिजर्वेशन रहता है वो उसको डिस्क्रिमिनेशन नहीं बोला जाएगा, क्योंकि वो अपलिफ्टमेंट के लिए किया जाता है. 10% ऑफ सीट्स फॉर सच सेक्शंस इन एडमिशन ऑफ टू एजुकेशनल institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This reservation of up to 10% would be in addition to the existing reservation. For this purpose, the economically weaker sections would be noticed by the state from time to time on the basis of family income and other indicators of economic disadvantage. The various provisions contained in Article 15. Article 15 में समराइज किया गया है रिजर्वेशन फॉर ओबीसी इन एजुकेशनल इंस्टीट्यूशंस. ओबीसी अदर बैकवर्ड कास्ट, द अबव एक्सेप्शन वाज एडेड. वो एडेड हुआ था 93 अमेंडमेंट एक्ट, जो कि 2005 में हुआ था. यहाँ पर प्रोविजंस ऑफ आर्टिकल 15, यहाँ पर 15 प्रोहिबिशन ऑफ डिस्क्रिमिनेशन ऑन ग्राउंड्स ऑफ रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ एट ए ग्लैंस. यहाँ पर 15 का 1 दिया गया है. द स्टेट शैल नॉट डिस्क्रिमिनेट अगेंस्ट एनी सिटीजन ऑन ग्राउंड्स ओनली ऑफ रिलीजन, रेस, कास्ट, सेक्स, प्लेस ऑफ बर्थ और एनी ऑफ देम. 15 का 2 में दिया गया है नो सिटीजन शैल बी सब्जेक्टेड टू एनी डिजेबिलिटी, लाइबिलिटी, रेस्ट्रिक्शन और कंडीशन ऑन ग्राउंड्स ओनली ऑफ रिलीजन, रेस, कास्ट, सेक्स, प्लेस ऑफ बर्थ और एनी ऑफ देम विथ रिगार्ड टू द फॉलोइंग: access to shops, public restaurants, hotel and places of public entertainment, or the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. 15(3) में दिया गया है the state is not prevented from making any special provision for women and children. 15(4) the state is not prevented from making any special provision for the advancement of any socially and educationally backwards classes or for the scheduled caste and scheduled tribes. This provision was added by the First Amendment Act 1951. 15.5 The state is not prevented from making any special provision for the advancement of any socially and educationally backward classes or the scheduled caste or the scheduled tribes regarding their admission to educational institutions. This also includes the private educational motivations, whether added or unaided by the state, except the minority educational institutions. This provision was added by the 93rd Amendment Act 2005. 15.6 में the state is not prevented from making the following: any special provision for the advancement of any economically weaker sections and a provision for the reservation of up to 10% of seats for such sections in admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This provision was added by the 103rd Amendment Act, जो कि 2019 में हुआ था. In order to give effect to this provision, the center enacted the Central Educational Institutions Reservation in Admission Act 2006, providing a quota of 27% for candidates. 2006 में एक तो रिजर्वेशन बिल पास हुआ था, एक्ट पास हुआ था, जो कि 27% कैंडिडेट्स बिलोंगिंग टू अदर बैकवर्ड क्लासेस ओबीसी लोग का प्रिफरेंस मिलेगा इन ऑल सेंट्रल हायर एजुकेशनल इंस्टीट्यूशन इंक्लूडिंग द इंडियन इंस्टीट्यूशन ऑफ टेक्नोलॉजी एंड द इंडियन इंस्टीट्यूट ऑफ मैनेजमेंट. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act, but the court directed the central government to exclude the creamy layer, जो कि advanced sections को creamy layer बोला जाता है, among the OBC, while implementing the law. The children of the following different categories of people belong to the creamy layer among the OBC and thus will not get the quota benefit. Persons holding constitutional posts like president, vice president, judges of SC and SCs, chairman and members of UPSC, SPSC, CEC, CSG and so on. Group A, Class 1 and Group B, Class 2nd officers of the All India Central and State Service and employees holding equivalent post in PSUs, banks, insurance organization, universities, etc. are also in private employment. Persons who are in the rank of colonel and above in the army and equivalent post in the Navy, Air Force and on paramilitary force. Professionals like doctors, lawyers, engineers, artists, authors, consultants, and so on. Persons engaged in trade, business, and industry. People holding agricultural land above a certain limit and vacant land or building in urban areas. Persons having जिसका gross annual income of more than 8 lakh or possessing wealth above the exemption limit in 1993 when the creamy layer ceiling was introduced. Creamy layer ceiling introduced किया गया था 1993 में. It was rupees 1 lakh. It was subsequently revised to 2.5 lakh in 2004, 4.5 lakh in 2008, 6 lakh in 2013 and 8 lakh in 2017. Reservation for EWS educational institutions. The above exception was added. ये 103rd Amendment Act में ऐड किया गया of 2019. In order to give effect to this provision, the central government issued एन ऑर्डर, सेंट्रल गवर्नमेंट एक ऑर्डर इशू किया था, कब ना 2019 में, प्रोवाइडिंग 10% रिजर्वेशन टू द इकोनॉमिकली वीकर सेक्शंस. Economically weaker section, EWS stand for economically weaker section in admission to educational institutions. कितना परसेंट रिजर्वेशन था? 10% रिजर्वेशन था. The benefit of this reservation can be availed by the persons belonging to economically weaker sections who are not covered under any of the existing schemes of reservation for SC and ST and OBC. The eligibility criteria laid down in this regard, क्या eligibility criteria रहा है? Persons whose family has gross annual income, जिसका gross annual income रहेगा 8 lakhs, are to be identified as economical weaker sections for the benefit of reservation. The income would include income from all sources, salary हो, agriculture, business, profession, and it would be income for the financial year prior to the year of application. Persons whose family owns or possessions any one of the following assets are to be excluded from being identified as economically weaker sections irrespective of the family income. 5 acres of agricultural land and above, residential flat 1000 square feet and above, residential plot of 100 square yards and above in notified municipalities, residential plot of 200 square yards and above in area other than notified municipalities. The property held by family in different locations or different places, cities would be clubbed while applying land or property holding test to determine economically weaker section status. These are the criteria to check economically weaker section or not. Family for this purpose would include the person who seek benefit of reservation, his or her parents and siblings below the age of 18 years, as also his her spouse and children below the age of 18 years. उसके बाद आता है इक्वालिटी ऑफ अपॉर्चुनिटी इन पब्लिक एम्प्लॉयमेंट. एम्प्लॉयमेंट के बारे में कौन सा आर्टिकल डील करता है? आर्टिकल 16. आर्टिकल 16 प्रोवाइड्स फॉर इक्वालिटी ऑफ अपॉर्चुनिटी फॉर ऑल सिटीजन्स इन मैटर ऑफ एम्प्लॉयमेंट और अपॉइंटमेंट टू एनी ऑफिस अंडर द स्टेट. No citizen can be discriminated against or be ineligible for any employment or office under the state on grounds of only religion, race, caste, sex, descent, place of birth or residence. सभी को अपॉर्चुनिटी दिया जाएगा और अपॉर्चुनिटी सभी के लिए बराबर है, लेकिन नो सिटीजन कैन बी डिस्क्रिमिनेटेड, यहाँ पर डिस्क्रिमिनेट नहीं किया जा सकता है अगेंस्ट टू बी इनएलिजिबल फॉर एनी एम्प्लॉयमेंट और ऑफिस अंडर द स्टेट ऑन ग्राउंड्स ऑफ रिलीजन, रेस, कास्ट, सेक्स, डिसेंट, प्लेस ऑफ बर्थ. देयर आर 4 एक्सेप्शन, लेकिन यहाँ पर भी एक्सेप्शन है, जैसे कि पार्लियामेंट कैन प्रेस्क्राइब रेसिडेंस एज ए कंडीशन फॉर सर्टेन एम्प्लॉयमेंट और अपॉइंटमेंट इन ए स्टेट और यूनियन territory or local authority or other authority as the public employment requirement as to residence. Act of 1957 expired in 1974. There is no such provision for any state except Andhra Pradesh and Telangana. The state can provide for reservation of appointment or post in favor of any backward classes. Backward class OBC के लिए रिजर्वेशन रहता है. That is not adequately represented in the state service. Also, the state is empowered to provide for reservation in promotions with consequential seniority in the service under the state in favor of the scheduled caste and scheduled tribes are not adequately represented in the state service. Further, the state is empowered to consider the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding years or years, and such class of vacancies are not be combined, वो combined नहीं होगा with the vacancies of the year in which they are being filled up, to determine the ceiling of 50% reservation on total number of vacancies of that year. Provisions of Article 16, Equality of Opportunity in matters of public employment at a glance. यहाँ पर आर्टिकल 16 का दिया गया है, जैसे 16(1), there shall be equality of opportunity for all citizens in matter relating to employment, appointment to any office under the state. 16(2), no citizen can be eligible for discriminated against any employment or office under the state on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them. 16(3), Parliament is not prevented from making any law prescribe residence as a requirement for certain employment or appointment to an office under the government of state or union territory or any local or other authority within them. 16 का 4 है, द स्टेट इज नॉट प्रिवेंटेड, प्रिवेंट नहीं करता है फॉर मेकिंग any provision for the reservation of appointments of post in favor of any backward class which is not adequately represented in the service under the state. 16(4)(a), the state is not prevented from making any provision for reservation in matters of promotion with consequently sincerity in the service under the state in favor of the scheduled caste and scheduled tribes which are not adequately represented in the services under the state. The provision was added, वो added हुआ है 77th Amendment Act 1995. Later the 85th Amendment Act 2001 made a modification in this provision by including the consequential seniority. 16(4)(b), the state is not prevented from considering the unfilled reserved vacancies of a year as a separate class vacancies to be filled up in any succeeding year of years. Further, such class of vacancies are not be combined with the vacancies of the year in which they are being filled up, to determine the ceiling of 50% reservation on total number of vacancies of this year. This provision was added, ये added हुआ था 81st Amendment Act 2000 में. 16(5), the operation of any law is not affected even though it provides that the incumbent of any religious or denominational institutions or any member of its governing body should belong to that particular religion denomination. The state is not prevented from making any provision for the reservation of up to 10% appointment of post in favor of any economically weaker sections. Or this provision was added by the 103rd Amendment Act 2019. A law can provide that the incumbent of any office related to religious or denominational institutions or a member of its governing body should belong to the particular religion or denomination. This means that the appointment of the office bearers in any religious or denominational institutions can be restricted to the persons of that particular religion or denomination. In brief, the religious qualification can be prescribed, वो prescribed किया जा सकता है by the law in this regard. The state is permitted to make a provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker sections. This reservation of up to 10% would be in addition to the existing reservation के लिए रहेगा For this purpose, the economically weaker sections would be notified by the state from time to time on the basis of फैमिली इनकम, इसीलिए इनकम सर्टिफिकेट देखा जाता है, और अदर इंडिकेटर्स ऑफ इकोनॉमिक डिसएडवांटेज. The various provisions है contained in Article 16 जैसे मंडल कमीशन and aftermath. In 1979, जो मोरारजी देसाई गवर्नमेंट appointed the second backward classes commission under the chairmanship of BP Mandal, a member of parliament, in terms of Article 340 of the Constitution to investigate the condition of the socially and educationally backward classes and suggest measures for their advancement. वो किया गया था कि इन्वेस्टिगेट करो जो सोशल इकोनॉमिकली बैकवर्ड क्लास कास्ट बैकवर्ड क्लास सोसाइटी में कितने हैं. द कमीशन सबमिटेड इट्स रिपोर्ट इन 1980 और कमीशन ने सबमिट किया था रिपोर्ट को 1980 को एंड आइडेंटिफाइड एज मैनी एज 3,743 caste as socially and educationally backward classes. They constitute nearly 52% component of population excluding the scheduled caste and scheduled tribes. The commission recommended for reservation of 27% government jobs for the other backward classes OBC, so that total reservation for all SC, ST and OBC ये सब को मिलाकर 50% हो रहा है. It was after 10 years in 1990 that the VP Singh government declared reservation of 27% government jobs for the OBC. Again in 1991, the Narasimha Rao government introduced two changes: preference to the proper section among the OBC in the 27% quota, adoption of the economic criteria in granting reservation and reservation of another 10% of jobs for other economically backward sections who are not covered by any existing schemes of reservation. In the इंदिरा स्वाहाने केस जो कि 1992 में हुआ था, also called as the मंडल केस, the scope for extent of Article 16(4) which provides for reservation of jobs in favor of backward classes has been examined thoroughly by the Supreme Court, though the court reject किया था the additional reservation of 10% for other economically backward sections. It upholds the constitutional validity of 27% reservation for the OBC with certain conditions. The advanced sections among the OBCs जो कि क्रीमी लेयर बोला जाता है should be excluded from list of beneficiaries of reservation. No reservation in promotions. Reservation should be confined to initial appointments only. Any existing reservation in promotions can continue for 5 years only. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. The carry forward rule in case of unfilled backlog vacancies is valid, but it should not violate 50% rule. A permanent statutory body should be established. Examine complaints को examine किया. Over inclusion and under inclusion in the list of OBCs. No relaxations in qualifying marks and standards of evaluation in matters of reservation in promotions due to the requirement of maintenance of efficiency in administration under Article 335. With regard to the above rulings of the Supreme Court, the government has taken the following actions. Government यही सब एक्शन लिया. रामनंदन कमिटी वाज अपॉइंटेड. रामनंदन कमिटी अपॉइंट हुआ था. क्यों? टू आइडेंटिफाई द क्रीमी लेयर एमंग द ओबीसीज. It submitted its report 1993 which was accepted. National Commission for Backward Classes, यहाँ पर कौन सा कमीशन कब सेटअप हुआ था उसका बारे में दिया गया है. नेशनल कमीशन फॉर बैकवर्ड क्लासेस वो एस्टेब्लिश हुआ था 1993 में बाय एन एक्ट ऑफ पार्लियामेंट. इट्स मैंडेट was to examine the complaints of under inclusion, over inclusion, and non inclusions of any class of citizens in the list of backward classes for the purpose of job reservation. Later, the 102 Amendment Act 2018 conferred a constitutional status on the Commission and also enlarged its functions. For this purpose, the amendment inserted a new article जो कि 338B in the Constitution in order to nullify the ruling with regard to reservation in promotions. The 77th Amendment Act जो कि enacted हुआ था 1995, it added a new provision in Article 16 that empowers the state to provide for reservation in promotions of any services under the state in favor of the SCs and STs that are not adequately represented in the state service. Again, the 85th Amendment Act जो कि 2001 provides for consequential seniority in the case of promotion by virtue of rule of reservation for the government servants belonging to the SC and STs with retrospective effect जो कि 1995 से हुआ था. The ruling with regard to backlog vacancies was nullified by the 81st Amendment Act 2000. It added another new provision in Article 16 that empowers the state to consider the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding year. Further, such class of vacancies are not to be combined with the vacancies of the year in which they are being filled up. Determine the ceiling of 50% reservation on total number of vacancies of that year. In brief, it ends the 50% ceiling on reservation in backlog vacancies. The 76th Amendment Act जो रहा है of 1994 has placed the Tamil Nadu Reservation Act of 1993, the ninth schedule, to protect it from judicial review, as it provided for 69% of reservation far exceeding the 50% ceiling. In order to nullify the ruling with regard to relaxations in qualifying marks and standards of evaluation in matters of reservation in promotions, the 82nd Amendment Act जो कि enacted होता है 2000 में, it added new provision in Article 335 that empowers the state to make any provision in favor of the SC and STs for relaxation in qualifying marks, nor lowering the standards of evaluation in matters of reservation in promotions. Reservations for economically weaker sections in public employment जो कि the above exceptions was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order providing 10% reservation to the economically weaker sections in civil posts and services in the government of India. The benefit of this reservation can be availed by the persons belonging to economically weaker sections who are covered under any of existing schemes of reservation for SC, ST and OBCs. The eligibility criteria laid down in this regard has already been explained. ये explain किया गया है Article 15 में. Further, the scientific and technical post which satisfy all the following conditions can be exempted from the purview of the reservation. The post should be in grades above the lower grade in Group A of the service concerned. They should be classified as scientific or technical in terms of cabinet secretariat order, according to which scientific and technical post for which qualifications in the natural science or exact science, applied science, or in technology are prescribed, and the incumbents of which have to use that knowledge in the discharge of their duties. The post should be for conducting research or for organizing, guiding, and directing research. A post research or organizing, गाइडिंग एंड डायरेक्टिंग रिसर्च के लिए जो पोस्ट रहेगा उसमें भी रिजर्वेशन रहेगा. The remaining part of this chapter we will discuss in the next class. Thank you. Like, share, and comment.